Has the court started?
No, courts have not started, sir. Now we have the audience coming in. Only virtual courts are going on, sir.
Okay. You are able to see the people coming in?
Yes, sir, I can see the names.
Okay. You should be giving this talk.
No, sir, I gave one talk. You have more experience.
No.
So I'll start in a minute.
Okay, no problem.
I have the pleasure of welcoming all of you to this webinar, which has been organized by the Interactive Session of Lady Lawyers. The interactive session is an informal group of women lawyers practicing in the Bombay High Court who have initiated a program of continuous legal education. The sessions conducted as a part of this initiative have been given by several legal luminaries, including Supreme Court, High Court, sitting and former judges, as also senior members of the bar. Today, we have the pleasure of having amongst us Justice Variava, who has so kindly agreed to address us on the topic arbitration proceedings and expectations of the arbitrator. I am indeed privileged to have been given the opportunity to introduce Justice Variava, before whom I have appeared on several occasions and who commands my deepest respect. Justice Variava graduated as a lawyer in 1963 from Government Law College and joined the chambers of the illustrious Sir Jamshedji Kanga as a junior of Mr. Marasban Mistry. As a counsel, Justice Variava handled mainly commercial litigation and company matters. He also handled some civil litigation in the City Civil Court. Justice Variava was appointed as a judge of the Bombay High Court in November 1986, became Chief Justice of the Delhi High Court in May 1999, and was elevated as a judge of the Supreme Court in May 2000, from where he retired in November 2005. Justice Variava, throughout his long and illustrious career, has always followed the highest principles of judicial conduct. He decided complex and high-stake matters without fear or favor, and his integrity has at all times been unquestionable. When the Harshad Mehta scam broke, Justice Variava was appointed as the sole judge of the special court, which was specially constituted to deal with all scam-related matters. As such judge, he decided hundreds of matters, both civil and criminal. After retirement, Justice Variava has been practicing as an arbitrator and as a legal consultant. I must say that he is a much sought after arbitrator. I can go on extolling the virtues of Justice Variava, but I shall now hand over the floor to him and request him to address us all on the topic arbitration proceedings and expectations of the arbitrator. But before I do so, I would like to give one instruction which I have been told to pass on. For the audience to ask questions, which we will seek to answer at the end of the session, there are three dots on the left-hand side of your screen. If you click on those three dots, you will get a question mark where you can put in your questions, and we will try and answer as many as we can at the end of the session. Justice Variava, if you may please address.
Thank you. Thank you very much. Good evening, everybody. Today's topic is arbitration and expectations of an arbitrator. I am expected to give you some idea of what arbitrators like to see during the course of arbitration. I can only speak of my personal experiences and expectations, as each arbitrator will have his or her own preferences. As you must all be aware, arbitration is a method of settlement of disputes by way of an alternative to normal judicial method. Arbitrations are thus an alternate dispute resolution process. Other forms of ADR are mediation, conciliation, negotiation, etc. Of all of these, arbitrations are the most preferred. An arbitration is supposed to be speedier and less costly alternative to resolving disputes in court. I will deal with later with whether this object is achieved. In India, arbitrations are governed by the Arbitration and Conciliation Act 1996. This act replaced the 1940 Act. This act enacted to consolidate the law relating to domestic arbitrations, international commercial arbitration, and enforcement of foreign arbitral awards. It also contains law relating to conciliation. Part 1 of the Act deals with domestic arbitrations. Part 2 deals with enforcement of certain foreign awards, and Part 3 deals with conciliation. The 1996 Act seeks to confer on the arbitral tribunal complete power to fully and finally dispose of the matters before it. The Act has tried to make arbitrations a complete and self-concerned alternative to disputes in the court, and seeks to keep judicial interference to the minimum. I'm sure most of you are more familiar with the Act than I am. I will therefore talk more about my experience and expectations as an arbitrator. As Fasana mentioned, I have retired as a judge in 1995 and have been acting as an arbitrator since then. Since then, I must say that not only as a judge but also an arbitrator, I found the Bombay Bar to be the best. I'm not trying to praise you all, but in most cases, Bombay Bar is very professional in their approach. Therefore, what I may say today may be things which many of you are already conscious of. The thoughts which I am sharing are not necessarily in their order of importance, but state thoughts as they arise. First of all, I have found that in many cases, the party nominating the arbitrator expects the arbitrator to support them and side with them. Parties forget that once an arbitrator is appointed, he becomes the arbitrator for the matter and not an arbitrator for the party nominating. I found many parties being surprised when the arbitrator nominated by them acts independently or voices a view against the nominated party. They forget that an arbitrator has to be an independent party. Parties should not expect arbitrators nominated by them to only favor them. I am glad to say that in all these years, only on rare occasions I found that an arbitrator does not act independently and tries to favor the party nominating. I have come across only two such instances. In both these cases, the concerned arbitrator had to give a minority award. Another aspect is that it is wrongly assumed that an arbitrator must be a retired judge or a lawyer, and not a layman or an officer of one of the parties. The 1996 Act does not lay down any such requirement or restriction. It is not uncommon to have arbitration clauses which provide that the arbitrator will be an officer of the party, or that the arbitrator will be nominated by the officer of the party, or that the arbiter will be an engineer or chartered accountant or an expert in a particular field. The amended 1996 Act no longer permits an officer of the party to be act as an arbitrator for obvious reasons, unless the parties agree to in writing after the dispute has arisen. I have sat in a number of matters where the other arbitrator or arbitrators are not judges but laymen or an officer of one of the parties. Even though such persons may not be very familiar with legal procedures, I found that they do have a good sense of equity and fairness and act independently. Also, nowadays, the High Court has been appointing young advocates arbitrators. That is a good thing, as young advocates have time to conduct arbitration. The fees are also such that enable smaller matters to be resolved in a cost-effective manner. Of course, now in arbitration, where the court appoints the arbitrator, the Act itself prescribes the schedule of fees that can be charged, and it depends on the value of the sum in dispute. Many of us old arbitrators are not accepting arbitration with those fees, but this is a point of view, and I cannot and will not say that the scale of fees laid down is unreasonable. The amended Arbitration Act now lays down certain grounds of disqualification to act as the arbitrator and requires the arbitrator to make declarations. I do not wish to discuss whether this was necessary to lay down these conditions. I believe, and as far as I know, most of the arbitrators were observing these conditions in any case. One of the things I would like to point out is whether the arbitration is ad hoc or institutional. Normally, till an award is given, both parties are required to pay fees and share expenses. However, I find that nowadays the trend is increasing for respondents not to pay their share of fees or expenses. Section 38 provides for deposits. They can be separate deposits for claims and counterclaims. Section 38 provides that if one party does not pay, the tribunal may call upon the other side to pay. If the other side also does not pay, then the claim or counterclaim, as the case may be, dismissed. The result is that if the respondent has not filed a counterclaim, generally the respondent does not pay fees or share expenses. Obviously, the claimant will not want to pay the respondent's share. But as no counterclaim is filed, the tribunal cannot penalize the respondent in any way. The claimant will not want his claim dismissed. So generally, the claimant will be forced to pay the respondent's share on the claim and bear all expenses. The only thing the tribunal can do, if it considers it just as necessary, is to grant an award in favor of the claimant for the sums he has paid on behalf of the respondent. But that means the claimant will have to be reimbursed only on execution of the award. Arbitrations are supposed to be expeditious, alternate dispute resolution. However, in my experience, there are several delays in arbitration for which both the advocates and the arbitrators are to be blamed. Unnecessarily, adjournments are taken, lengthy and unnecessary cross-examination undertaken, irrelevant submissions made. Therefore, I want to briefly dwell on what I feel are important and reasonable expectations from the arbitrators appearing in the arbitrations. By the time a dispute is referred to arbitration, it is expected that claimant is aware of his own case. That is to say, he must certainly be aware of the claims he intends to raise in arbitration and the facts giving rise to such claims. In almost all cases, the claimant has already issued a notice invoking arbitration, setting out bare bones of his case. It is therefore frustrating to see a claimant appearing at the first hearing of an arbitration and taking 2 months' time to file their statement of claims. The statement of claim should be ready, or at least ready by this time. The respondent is also aware, mostly through previous correspondence, of the general nature of the dispute or claims made against him and can begin his preparation in terms of collating the relevant documents. This would greatly reduce the time taken to complete readings. After the recent amendment of the Arbitration Act, statements of claim and written statement, that is the pleadings, are to be completed within 6 months from the date the tribunal is constituted, and the award is to be made within 12 months thereafter. Hopefully, this will encourage parties to start preparing their pleadings in a timely manner. When drafting your pleadings, try to be concise and direct. Don't beat about the bush. In this, instead, state upfront the point you wish to make and the material you rely upon in support of this. As an arbitrator, I have come across pleadings which are long and verbose. A setup case it could easily have been narrated in half the space. You must try to make your language clear and precise. Use short sentences and clear language and try to avoid legal jargon. Long winding sentences and explanations that lead to nothing often give the arbitrator the impression that the party is either shying away from the truth or has no plausible answer to the case it has to meet. It is important to remember that while drafting the pleading, the award is now required to be made within 12 months of the completion of the pleading. Therefore, the examination and cross-examination of witnesses will happen almost immediately after completion of hearing and not several years later, as happened in court cases. Therefore, my advice to all lawyers would be to speak with your potential victim at the time of preparation of the pleadings itself. I often see that evidence affidavits and even oral arguments go beyond pleadings on important matters or is sometimes contrary to what is in the pleadings. Speaking to witnesses at the time of preparing pleadings also give you a much better idea of the strength and weaknesses of the case and allow you to structure your case from the beginning. There are a few important points I believe all advocates should keep in mind while presenting their case. One of the most important things I want to point out to you today is that, in my experience, both as a judge and an arbitrator, one expects the appearing advocate to be fully prepared. There is no excuse for appearing before a court or a tribunal underprepared and unready to go on with the matter. As I have said already, if you are a junior advocate being led by a senior, you must be absolutely prepared to go on with the matter if for any reason the senior is unavailable. You must treat it as an important opportunity and seize it with both hands. Being well prepared on a consistent basis will build up your reputation and credibility in the profession among judges, opponents, and colleagues. Also, do not become too involved with your client's case. Try and do not make up a false case. Just to give an example, I have had arbitration where a contract was to be performed in stages. In the written statement, it was categorically indicated that stage one was completed. In spite of this admission, the senior counsel wasted time to prove and then argue that stage one was not completed. When asked why this time was being wasted, the senior counsel had the temerity to say that as counsel, it was his duty to do everything for a client. I had to tell the senior counsel that his first duty was to the profession and that it was no part of the counsel's duty to make up a non-existent case or go contrary to pleadings. Making outstanding submissions and pitching your client's case does more harm than good, both to you and your client. As a lawyer, you lose credibility with the tribunal. The tribunal is given the impression that you lost all objectivity as a lawyer. It also reflects from the stronger points of your client's case. I would suggest that you carefully select your stronger points and urge those first, for they are most likely to bring success for your client. Don't dwell too much on technically or procedural irregularities, especially in arbitration. Remember that your arguments must appeal to the common sense and the sense of justice. You must be able to ascertain for yourself what arguments are reasonable and what are absurd. You must separate the grain from the chaff. In order to do this, you need to carefully study the law of each aspect before making your arguments. In one matter before me, interest was being claimed on interest, just not from the date of the award, but from an earlier period. The senior counsel, being the senior counsel, argued very convincingly that interest on interest should be granted. This was the party's case, so counsel could not be stopped from so arguing. If the counsel had been stopped, it would have been argued in proceedings under Section 34 that the party was allowed or given proper opportunity. I contrast this with a case where a senior counsel was bold enough to stand up and say in court that he had no particular case. Arbitrators appreciate when advocates fairly concede an indefensible point. It saves both time and effort. Examination of witnesses usually takes a long time, in part because of a lot of irrelevant questions asked. I've had a matter where a senior counsel insisted on cross-examination a witness for days, asking over 1,000 questions. Thereafter, during submission, no reference is made to that evidence. This is an absolute waste of time and unnecessary. I know that many of you are thinking, why in the above cases the tribunal did not self-counsel. That is not an easy thing to do. One has to enter into an argument with counsel, and even if one succeeds, a ground will be taken that the party was not given full and fair ground or proper hearing. You must also carefully read beforehand the judgments that you intend to cite before a tribunal for a particular proposition. Pick out the best and most recent case law and only cite those. Citing 8 or 9 judgments on the same point of law will not get you any further, and you risk losing the attention of the tribunal. It is also important to cite case law that goes against you, even if the other side has not done so, and to distinguish it if possible. This not only increases your credibility, but also ensures that the award is correct and less likely to be set aside. There have been times when I have done research on a point of law on my own, and I found cases directly on the point that neither side has cited. In my view, this should not happen. In my experience as an arbitrator, I often found that the advocates treat arbitrations as a stepchild and prefer that court work. This, in my opinion, should never happen. If you have accepted arbitration, you must give it the same importance as any other matter, whether in court or any other tribunal. Some advocates prefer to fix their arbitration for just 1 or 2 hours in the evening after court hearing or on weekend so that it does not interfere with their matters in court. I am not in favor of such a practice. Another thing I found is that some lawyers, particularly seniors, attend arbitration only during the period when the claimant is being examined only for their own submission. Our lawyers consider this to be a wrong thing. Once you accept the matter, you must give 100% to the matter. In my view, it is not correct to try and earn from everywhere. Even though not too much in Bombay, I find that lawyers and even on rare occasions an arbitrator is more important to court cases and treats arbitration as a stepchild. This should not happen. If you accept the arbitration, it should be given the same importance as a court case. In any case, once a lawyer is in arbitration, he cannot expect to go to court and attend to court cases at the same time. As you are well aware, there can be ad hoc arbitrations where the parties or their lawyers directly appoint the tribunal, or there can be institutional arbitration from institutions like LCA or the Singapore Center of Arbitration or ICC. The institutional arbitration are by and large expensive, and there have been some criticism that foreign arbitrators are biased in favor of their parties. But I have not found the same to be true. Indian arbitrations can be very expensive. Nowadays, most arbitrators charge hefty amounts. Of course, the Indian Act now lays down a scale of fees. Many of the all arbitrators are not accepting the fees, but it is a point of view, and I cannot and will not say that the fees laid down is unreasonable. Another thing which must be mentioned is that Section 34(4) permits remitting a matter back to a tribunal, give opportunity to remedy the challenge to the award. I have not come across any court resorting to this. This in my career has happened to me only once. There was an arbitration for specific performance of an agreement to sell some premises. One of the main defense was that it was not an agreement to sell, but was merely an agreement to enter into an agreement. The respondent had exhibited some documents. The claimant moved an application to be allowed to disclose and rely upon more documents, which the claimant claimed were part of the series of correspondence of the respondent had only disclosed part. During the hearing of the application, the respondent offered to have unmarked the documents exhibited by them so that the others need not be taken on record. The tribunal permitted this to happen. The court has now remitted the application back to the tribunal on the ground that the tribunal has no power to unmark documents, and the tribunal must decide whether the other documents sought to be disclosed by the claimant should also be taken back on record. The court has also ruled that if the tribunal takes the documents on record, then it must re-decide the matter. We still have to hear the application. It was fixed during the lockdown, but because of lockdown, it could not be heard. This is the only case I have come across of a court using Section 34(4). It is also worthwhile mentioning that when a client brings the matter to you, you must explore for yourself whether there is any possibility of a settlement. I believe the advocate should always endeavor to explore settlement. I've found that some advocates try and delay settlement, whereas keeping their own interests in mind. Advocates often make bold promises to the client in the early stages of the matter and give the client lofty expectations which makes parties reluctant to settle. However, as the trial progresses, it most often through cross-examination, a party realizes the flaws and weakness in his own case, and only then gets a more realistic idea of the chance of success. By this time, a considerable amount of time and money has already been spent. It is therefore an advocate's duty to give his client an honest and fair representation of his case from the beginning and urge his client not to make exaggerated or bogus claims. Just a minute, please. I have had a case where a party was seeking specific performance of an agreement to sell property, but that party had himself not performed many of the obligations under that agreement. Even though it was clear from the start that in such a case specific performance could not be granted, the other side fairly offered a settlement which I thought was very fair. Unfortunately, the senior counsel appearing in that matter would not permit the party to settle. Ultimately, the party, that is the claimant, lost before the tribunal. I do not know what happened thereafter. I do not know if Section 34 proceedings are filed and if any settlement took place in those proceedings. I have also had a family litigation where members of a family were very bitterly fighting. After some hearing, it was pointed out to both the sides the fatality of what they were doing. I am glad to say that in this case, both sides accepted the suggestion of the tribunal and the family settled the matter and are now very happy with it. One more other aspect is that when I had started arbitration, I found that parties generally disclose only those documents which are relevant, and if the other side wanted any more documents, they ask for it or they themselves disclose those documents. Nowadays, I find that parties tend to disclose all documents that they have in their possession. As a result, the violations become very voluminous and difficult to handle or store. Also, then what happens is that during submissions, parties do not rely on most of these documents and only rely on certain documents. Thus, they have then to file convenience compilations, which is against a nuisance and a duplication. Thus, try and avoid filing voluminous documents. One other aspect which is very anomalous is that if an insolvency proceeding are filed against the respondent, then the arbitration gets stayed once a moratorium is granted. However, if there is a counterclaim, legally there is no bar to the counterclaim going on. The question often arises whether the tribunal should go ahead with the counterclaim while staying the claim itself. It must be remembered that there will be a lot of common evidence between the claim and the counterclaim. So, the view that I have taken is that it is preferable to state the counterclaim also. But legally speaking, there is no bar to the counterclaim going on. There was one matter where the arbitration was in London. After I had reached London, the Indian party sent an email only to me requesting for an adjournment on the ground that his counsel had refused to come. The tribunal took cognizance of that email but refused to adjourn the matter and went on ex parte. The party filed an objection in the English High Court. If this had happened in the Indian court, it is possible that an Indian court would have said the principles of natural justice were not followed and more opportunity should have been given to the party. But the English court threw out the challenge and upheld the award. What I'm trying to say is that it is always better not to take the tribunal for a ride. I have also had an arbitration where the state of Maharashtra is a party. At one of the hearings, an adjournment was asked for by the state on the ground that some documents were in Marathi. Of course, the adjournment was not granted, but we found thereafter that the state had filed an affidavit of evidence of a person who had no personal knowledge at all. This was a fit case where the tribunal could have proceeded, but in order to give the state one more opportunity, the matter was adjourned and the state was afforded an opportunity to file a proper affidavit, of course, on payment of cost. But this shows that the advocates for the state had not advised the party properly, and the state unnecessarily had to pay cost. Unfortunately, I find that nowadays, even in private litigations, many advocates are not prepared and they do not possess even basic skills. It is therefore very important that every advocate must be completely prepared and have a mastery not only over his client's case, but also the case of the other side. An advocate must be ready also be ready with all the relevant law. They must try and anticipate what the other side is going to say or do and try and have an answer to that also. There is no substitute for hard work. I think I've said all that I can about my experience and expectations. As I've said earlier, I'm sure that all of you are very familiar with the law of arbitration. Thus, merely pointing out the basic provisions of the Arbitration Act is like taking coal to Newcastle. Thus, I refrain from doing so. I will now end my lecture. Thank you for giving me this opportunity to share my thoughts with you. Rosanna, I finished.
So so this is Rita. Till Farzana comes on, I will ask a few questions which our audience have asked.
Okay, do that, yes.
So the first question is, what are the powers of an arbitrator
Hmm.
if it is brought to his notice there is contempt of his order passed under section 17?
Unfortunately, the arbitrators do not have any powers to enforce their own orders. All that an arbitrator can do is make a reference to court and point out to the court that its orders are not being complied with. There are decisions of various high courts which say that on such a report, the high court should act and punish the party as if it was never contempt of itself.
So the second question is, how can we proceed with ad hoc arbitration during COVID-19? As due to lockdown, it has come to a standstill.
That's a very good question with which I am also struggling. I've implemented a lot of my arbitrations. Of course, that is video conferencing, but somehow I find that either the co-arbitrators or many lawyers are not willing to do video conferencing. Video conferencing may have some problems, but I can't tell you what they are until I've really tried it out myself. So far, I have not had any video conferencing. Farzana is back.
I think Farzana can take over now.
Yes. Okay, Anita, you asked one or two questions, right?
Yes, she asked the question.
So the next question is, can a respondent who has not filed a counterclaim ask for reliefs by way of a Section 17 application?
Yes, why not? If his case requires some relief to be granted, he can file. Tribunal will have to decide on its merits whether his case falls within Section 17 and whether he is entitled to release.
Okay, sir. The next question is, how should an arbitrator react if his award comes for caustic judicial criticism in proceedings where the award is challenged?
Most of the time, arbitrators do not come to know of this at all. But there is no occasion for an arbitrator to react. What the court says, arbitrator can't react to what the court says.
I agree with you, sir. In courts, normally we file affidavits of examination in chief just when our witness is about to step in. We are not
Yeah.
directed to file all affidavits in. Sorry, sir, can you hear me?
Yes, I can.
We are not directed to file all affidavits simultaneously. But very often in arbitration proceedings, arbitrators direct us to file all witness affidavits simultaneously. Sometimes that creates some difficulty because when our first witness steps in and there are certain things which we realize are not covered, if all affidavits of all witnesses have been filed, it becomes very difficult to cover those issues which may later on arise. How does one deal with this, sir?
As far as I can see, most of the times the evidence of a witness is not restricted to his affidavit evidence. Very often, the counsel for the party asks questions before the tribunal and thereby covers up whatever is left out. That is the procedure. But all parties are supposed to know what their case is. So there is no reason why parties should not file their affidavits together.
Okay, sir. Uh, when there's an electronic record produced before the arbitrator, are the requirements of Section 65B strictly required to be complied with, or how does one go about proving the electronic record in an arbitration?
As you are aware, the Evidence Act does not apply to arbitrations. I have consistently taken a view that Section 65B need not be complied with in arbitrations, as only the principles of natural justice have to be complied with and not strict rules of evidence.
So, therefore, if an email is produced, you will not ask for all the certificates which have to be filed along with electronic record.
Yes, I do not ask.
Okay, sir. So, what is your view on institutional versus ad hoc arbitration?
Very difficult to say. Both are good. Institutional arbitrations have their own benefits. They are generally better supervised, but they are very expensive. Most of them are. Ad hoc arbitrations enable the party to select an arbitrator, say a junior advocate, who nowadays are being appointed arbitrators, and therefore it can become more cost effective and a speedier remedy.
So, if sometimes the court appoints an arbitrator which parties are not very happy with, what is the remedy?
There are provisions in the Arbitration Act for challenging the appointment of an arbitrator and having his appointment revoked. You have to adopt those proceedings.
But the question was, if you don't fall within those four corners, then what do you do?
If you don't fall within the four corners, then you have to go on with the arbitration, and only at the stage of 34 you can raise whatever challenge you want.
Okay. Uh, what are the powers of an arbitrator if it's brought to his notice that in a Section 17 order there is contempt? If
But
a
that's the
Section
same as
17 order.
earlier. That's the same. That's the
Sorry,
same question as what I already. Isn't that
sorry,
the
sorry. I didn't hear that. Sorry, sir. Uh, Sir, what are the basic qualifications required from an arbitrator for an arbitrator? I know that the Act is not.
uh, there's no qualification required. As I had mentioned during my speech, I've sat with laymen, I've sat with chartered accountants, I've sat with engineers, I've sat with railway officers. That even though they may be connected with the institution or one of the parties, they do act very impartially. Most of the time, the legal provisions and procedures they leave to you. So I have had no difficulty with any of them. Though the amended act does not permit an officer of the party to be an arbitrator. And the amended act does have various disqualifications of an arbitrator. Those will have to be met.
Okay. So, when you talk about the Act does not permit any longer an arbitrator who is an officer of a party, but now with judgments, unilateral appointment is also kind of not permitted. How does one resolve this? Because there are lots of contracts with regard which banks have, their security documents, there are public sector contracts which all provide that the party
But,
can appoint the
but
arbitrator.
now the law will prevail, and one will have to go to court to have an arbitrator appointed.
Very well. And so the last question, you spoke about large compilations being filed in
Yes.
arbitration proceedings in the initial stages and later on convenience compilations being filed.
Yes.
The question that is asked is that this practice is normally followed so that there are no allegations made of suppression at a later date because one doesn't know what exactly the respondent is going to produce and what the respondent is going to allege. Therefore, sometimes things which are irrelevant or not absolutely and materially relevant are also filed. How does one address this issue then? How does one reconcile these difficulties?
The way I look at it, if the respondent wants some document, it can produce it itself if it can, or it can take out an application on the other side to produce it.
Okay, sir.
Filing irrelevant documents is does not serve any purpose.
Okay. Thank you, sir. I have finished my questions.
Thank you. Yes. Thank you very much.
Jay, you can take over.
Yes, I'll take over. Thank you. On behalf of our association, I would like to take this opportunity to present a vote of thanks to our esteemed speaker, Justice S.N. Variava. Thank you very much, sir, for sparing your valuable time and being here with us today to explain the law and practice relating to arbitration proceedings and expectations of an arbitrator. Today's lecture will immensely benefit all of us, the young and the senior lawyers, all of us. We are truly grateful to you, sir. Thank you very much. I also
Thank
take this
It has been
opportunity
my
to
pleasure.
thank I also take this opportunity to thank Mr. Harsh Sabale and the entire Jump Talk team for their efforts in making this digital platform available to us for organizing today's online session. I also thank Ms. Farzana Behram Kamdin for sparing her valuable time and smoothly conducting the session today. Thank you, Farzana. Let me also thank Anita and other members of the organizing team for organizing today's event for benefit of all of us. Last but not the least, I must thank all the participants for enthusiastically participating in today's session. Looking forward to see you all in our next session, which will be held on next Saturday, same time, same platform. We'll have yet another esteemed jurist, Justice Sujata Manohar, to speak on the topic of redefining the notions of equality and gender justice in India with reference to landmark judgments of the Supreme Court. Until then, goodbye, take care, stay safe, and have a great weekend. Thank you so much.
Thank you. Thank you.